Mr McCormick, can I move on to answers that you gave from estimates last year about the costs associated with an AAT case relating to colour vision deficient pilots? And you indicated that as of the 1st of December 2013, the costs were $43,500. Can you tell me, in terms of forecast costs, how many expert witnesses does CASA plan to call for that inquiry or that tribunal?
Are you talking about the upcoming O'Brien tribunal? Yes. In July? I'll ask my manager legal branch if I could to give you that figure. Thanks, Senator.
You guys are in government. Why don't you just pick up the phone and ring it? Just trying to help you out.
Senator Joe Rule, Manager, Legal Branch. There will obviously be a number of specialist witnesses called to give evidence.
10, 15?
I'm not across the precise number.
Would I be wrong if I said 12?
Look, I couldn't say that number's wrong or out of the ballpark, but I can't give a confirmed number at this stage. The exchange of evidence between the parties has only just finished at the end of last week, I believe, so there will be some toing and froing as to which evidence is required, which witnesses are required, but I can certainly take that on notice and provide a more settled estimate of that for you, if that would assist.
You must also have, and that would be good, but you must also have metrics from previous inquiries, knowing the cost, basically what expert witnesses charge for their appearance, travel and accommodation costs, the whole cost of conducting the inquiry in terms of transcript fees, etc. Have you made a provision in your budgeting for how much you anticipate this AET case will cost?
Look, obviously we do forward estimates of how much we think a case is likely to cost. Generally we do it across quarterly budget considerations, so total cost can get washed out as you conduct these cases.
I'm happy to add the figures up, Mr Rule, if you could give me the figures across those quarterly milestones.
We can certainly take that on notice and provide those figures.
Okay, but would it be a reasonable expectation that it would be at least another $43,500 on top of that, which you've already spent, if not significantly more?
It wouldn't be out of the realms of possibility to accumulate another $40,000 in costs, no.
Very understated remark, Mr Rule, but thank you. Could I ask Mr McCormick or Mr Rule, one or the other, in terms of whether or not you move ahead with this, my understanding is that you have an obligation, like any Commonwealth Department, to be a model litigant. And as I look at this, there's about 8 criteria to be a model litigant, and I see CASA not performing particularly well in about 5 of them. Can I ask, what's been the response to Mr O'Brien's request to reach a settlement before the hearing?
Third, Mr Rule, if he has any.
Well, there was a mediation conducted last year, in the early part of last year, which was ultimately unsuccessful, and I wasn't aware of any other proposal to...
Well, a letter from his lawyers written on in I think February this year.
Yes, I wasn't aware of the specific details of that proposal, but...
So you're planning to spend probably over $100,000, and you're not aware of an opportunity to actually reach a settlement before the AET hearing?
Well, I mean, I think at different points along the way, Mr O'Brien has suggested that he would be prepared to resolve the matter, but always on the basis that he have access to the privileges of his airline transport pilot licence. And that, of course, has been the sticking point, or the major sticking point from CASA's perspective, and the reason why those negotiations haven't been successful.
Yes, Senator, I think we've only got the legal costs as a total legal cost, but if you wish to give us on notice the specific areas you think we're not being a model litigant, and we will look at exactly what we've said in the past, And as Mr Rule has said, my understanding is that up till now, there has not been any indication that Mr O'Brien wishes to retreat from the position of holding an ATPL.
Sure. I guess I'm interested in two counts. One is natural justice, and we'll come to that in a minute, but the second is value for money for the taxpayer in going down this path. You said in the last estimates that you didn't believe CASA needed to be bound by the Denison case, and that you looked at individual circumstances as opposed to looking at a generic ruling that would apply to everybody. And you also mentioned that you'd be happy to look at the concept of a practical test to satisfy the third level of testing for CVD, which is required or allowed for under CASA 67-156 subpara C. Where have you got to in that regard, Mr McCormick, in terms of a practical test?
I'll ask my Principal Medical Officer to come forward in a minute and to maybe give you some more background on where we are. What 67 does say is that an applicant for a Class 1 or a Class 2 has to go through 3 stages of testing. The first stage being the Ishihara. If a person passes that, they get an unrestricted medical certificate. If they fail that, they have to do the Farnsworth-Lantern test. If they fail that, there is a third level of testing available, and I think 67 says that's at CASA's discretion what that test is. And this is where last time we discussed using the CAD test in the UK, CAA, as that third level, or some other test as it may be applicable. Before I ask Associate Professor Navati to add a bit more about this, if he wishes to, it's interesting to note that the UK CAA, since we spoke, has adopted the CAD test as their only test. If you fail that CAD test, you do not get a Class 1 certificate at all, let alone with restrictions.
Mere mortals. What's that test?
It's
They run you up a flight of stairs, or
It's a vision.
see if you can drink 2 minutes in a row, or
I think they're all worthwhile tests, but this particular test is associated with what degree of colour vision deficiency you have and the nature of it. Therefore, the medical staff are able to make a better assessment of the effect, and that's where the individual assessment of the case comes in. But 67 does say that you must go through those 3 steps in that order.
I understand. Before we go to Dr. Navathe, you did also say in that period that you didn't believe there was any intention to mandate the CAD test, and that wasn't the direction CASA was going. But I have subsequently seen a couple of examples where CASA refused to renew the medical of people who've previously had multiple renewals of their medical unless they sat the CAD test. Does that not contradict your comment that that's not CASA's intended direction?
I'll go back and check what I actually said it at the time, but my recollection of the conversation was we're talking about using the CAD test as the principal test, rather than the Ishihara or something like that. But as I said, I'll check that on notice. Our view still is that anybody who is entering the industry now and applies for a Class 1 medical certificate, or a Class 2 for that matter, follows 67150 as you've outlined it in those 3 steps as it says they should be done. So the difficulty with mandating the CAD test at the moment, apart from anything else, is the fact that it's only available in 2 places in Australia, and that's Adelaide and Sydney. And I believe it's quite expensive, so we don't necessarily want to go... Sorry?
$440.
Yeah, so we don't want to go to the point of pushing people into that test when there are other things available in that third level of testing.
Now, one of the other comments that you made during that estimate were talking about the alternative test that CASA makes available in the case of audio testing, which can include a flight test where people actually go up and fly and demonstrate their ability, and you indicated that you would look into that kind of a test. Have you made any steps in that regard?
We have not, well, there is, and again, I'll allow Professor Navate to answer this more fully. We have looked at practical tests, but of course the practical test is supported by the clinical and empirical evidence that we get from the medical testing. It's not a supplant of the medical testing as such, and I think that methodology of saying this is what the medicine shows, is what the data shows us on the ground, is the first step. So the practical test cannot always override the indications from the clinical pathology, if you will. But
Well, again, just before we go to Dr. Navathe, on that, your previous principal medical officers, being Brock, Liddell and Wilkinson, have all had a different view. They've respected the medical science, but Brock in particular has gone to ICAO, and some of his documentation indicates that at the working groups, I think the Vision and Colour, can't remember the exact term, Vision and Colour Deficient Working Group, they actually acknowledged that a lot of their current rule set weren't necessarily good at determining whether the person was competent to fly an aircraft. It was just good around determining if they had a colour vision deficiency. And it was for that reason that Mr. Brock, in fact, allowed people to do a flight test where they could demonstrate in an aircraft their ability to actually operate. And on that basis, there are now people who are CVD, and that's proven, and they don't dispute that, who are now operating airline aircraft as captains around the world. So CASA has, in fact, previously established a precedent that has shown that there is an alternate third level of testing that accepts the fact that somebody may have a CVD, but that is not a determinant as to whether they can actually competently and safely operate the aircraft. And so my question is, with all due respect to the theoretical approach which the CAA in the UK has taken, what steps have we taken to build upon Australia's 25 years of experience to provide an alternative means of demonstrating is the person safe in the aircraft, not does he or she have a colour vision deficiency?
Well, again, I think Professor Navati will be better able to expand on this. But of course, things evolve, and as the medicine evolves, and as the knowledge of colour vision deficiencies increases in the medical community, in other words, things will evolve, things will change, they will move forward. As for a flight test, the thing about flight tests, and I assume you mean airborne flight, as a practical test, is there are many, many conditions which come into play in the aircraft. A single test in the aircraft is not necessarily going to be indicative of the repetitivity of that particular performance at any one time. It is an indicator, but as I say, 67 at the moment has outlined quite clearly how we get to there. But again, if you don't mind, I'll ask Professor Navate to give you the background of where we are as far as that goes from ICAO's point of view or anyone else's point of view at the moment.
Sure, we'll go to Dr. Navate, but I'll just repeat, as I think we've discussed before, Mr. McCormick, that when I have given young people an instrument rating, a command instrument rating, that award is given to them for 12 months on the basis of their demonstrated performance on a day or within a check and training system. It is no guarantee of their performance tomorrow, and that is quite an accepted risk process that the aviation community has undergone. Dr. Navate, welcome.
Bhushan Navate, Principal Medical Officer, Senator. The point which you made about flight tests and the difficulty of tests identifying people who have got colour vision deficiency, but not identifying people who may or may not be fit because of that colour deficiency to operate in an aircraft was very true a few years ago. In around 10 years ago, the UK CAA, in addition with the local university, undertook a project to identify the specific colours which are important to aviation. This was a three-phase project. The first phase was to look at the important colours outside the cockpit. The second phase was to identify the colours inside the cockpit, for which they used an Airbus and a Boeing cockpit. And the third phase was to identify a test which would separate people who had abnormal colour deficiency from those who had abnormal colour deficiency but who were not colour safe. So that was the intent of this project, and that is how the CAD test has been developed, Senator. So what the CAD test does is to specifically identify those colours and people who are able to meet the colour requirements for aviation. As a result of that, about a third of the people who have previously failed tests like the Ishihara or other colour vision tests have now been able to pass the CAD test and are operating safely. As a result of that, in many jurisdictions in the world, it is the primary test which is being used. In Australia, it has been proposed as being the tertiary level test if a person is unable to pass the Ishihara or the Farnsworth Lantern test. Now, what you mentioned about the use of a flight test has been done in some jurisdictions, and they have been criticized for the difficulty of standardization. The big difficulty about a color vision test is it's an input disability. When we are looking at a output disability of, say, for instance, a restriction to an arm or some sort of amputation or some output limitation, that is easily correctly assessed, like performance is assessed in a flight test or in a simulator test. The difficulty with trying to do that with an input is that you do not know where is the break in the link. Is it because it wasn't picked up? Is it because it wasn't bright? Is it because there was distraction? There's a whole host of factors involved in that, as also inter-operator and inter-tester variability. So that's been criticized in the US as well, where they use medical flight tests. And there's a recommendation in the US, which came out of a study last year, suggesting that if a person fails the initial clinical test, the second test should be a precision test, such as a CAD test. So the research which has come out in the last 4 or 5 years has changed the complete picture for that, and that's why the attitude is moving in that direction, Senator.
Could I just raise a procedural issue with the guidance of the committee? We're going to do air services tonight. How much time do we need?
I've probably got another 15 to 20 minutes, and I believe they'll be adequate for air services.
So,
This is your one, mate, don't look at me, I'll put them on notice.
oh yeah, Senator Smith's got a couple of questions for air services, so we'll say 25-2 will go to air service.
Okay. Dr. Mccarthy, there are two confounds with that approach. One, a very simple example. In my past at military college, they used to have language aptitude tests, a theoretically derived test, and our counterparts from countries in Asia weren't normally sitting those. A Chinese origin Singaporean student sat the test, failed dismally, was told he had no aptitude for tonal languages. The similar confound for you is that pilots who have been safely flying for tens of thousands of hours have failed the CAD test and yet have demonstrated in not just one test but multiple check and training tests with multiple instructors their ability to safely operate aircraft. And so if the contention that Mr McCormack made that CASA approach this on an individual capacity basis as opposed to one rule, then you can't discount the fact that a theoretical test will not necessarily determine an individual's ability to use other cues to operate an aircraft safely. You mentioned that they looked at internal and external lights. It is a proven fact that in aircraft that are modified for night vision imaging systems, where all the emitted light is filtered with something like a BG7 filter, that the colour hierarchies are completely disrupted, and yet aircrew and fixed-wing and rotary-wing aircraft, normal colour pilots, quite safely operate those aircraft in terms of interpreting that internal information. Likewise, external information. The human body adapts, things like hyperstereopsis. It, for years, was said that that would make it impossible to fly, and yet the body adapts to that. And so what you're seeing in the cases of this pilot, one of whom I understand you attempted in 2009 to actually not renew his medical, but subsequently gave it back to him to continue flying as a captain in an ATPL situation, has not passed the CAD test, but demonstrates that he as an individual is able to competently fly an aircraft by day, by night, in IFR conditions. And so my question to CASA is, from a point of view of procedural fairness and natural justice, is it a good use of the taxpayers' money to take these issues through to well over $100,000 in an AAT hearing when there are proven methods of establishing the competence of an individual to operate an aircraft?
If I could, Senator, I think we don't know what the sum of money involved is, but we'll go with what you're saying at the moment. The overriding principle here, whether it's colour vision deficiency, hearing deficiency, any sort of impairment on the pilot, is safety. At the moment, to go towards an ATPL when there is no standard to which we are aware of which ATPL is issued anywhere in the world, to go to that situation for what would be the benefit of a number of pilots. I think we're talking a few hundred pilots in total. I agree, they should be able to do the best they can in their career, but our responsibility is to maintain the safety of the Australian travelling public. And when we get to the point of view where we are pushing the boundaries, where we're pushing the science, looking for other ways to get around what could possibly be indicated from the clinical side that is a dangerous thing to do, then we're starting to impact on my ability to discharge my duties under Section 9 of the Civil Aviation Act, and that is to provide safety as it is outlined in that Act. Now, if we wish to go there, then we have to go there in a measured manner. We will not go there on one basic flight test, and I'm sorry, we will research this as much as necessary, and with all due respect, I will not be issuing an ATPL to a person who fails the test as outlined in 67. Those who already have their licence and have their privileges, we intend to do nothing with them. We will say to them, we are writing to them, as I mentioned to you the other day, to say to them, if you've had some change in your vision, or if you think something's changed to affect you, then perhaps you should discuss it with your own doctor or with your own DAMI. I agree we should move forward, but we are already way out in front of half the world, if not 3/4 or all the world, and as we move forward, we will do it at a measured pace. When O'Brien goes through the AAT, we will see what the AAT has to say, what their decision is, what their preferred decision is, and that will give us the basis from which we can move forward, whether it be in practical tests or whether it be in clinical tests or whatever combination is required. To do it now unilaterally would be dangerous.
Can I take you...
Mr. Rule, you need oxygen, you appear to have glazed over.
No, I'm
You're all
quite
right.
all right, Senator. Thank you.
Thanks.
Hey, what about me? I haven't
Thanks,
got
Chair.
oxygen. I'll have some.
Mr McCormick, can I take you then, if you're concerned about Australia moving ahead of the rest of the world, to both the retirement age of pilots and also CASA's world-leading work in the area of pilots suffering from depression who are able to fly while being treated with SSRIs. Now, in both those cases, Australia was well ahead of the world.
I
And
agree.
Australia ended up not saying we're ahead of the world, therefore we shouldn't go here, but in fact Australia took that information to the world, and now the world has changed its retirement age and it's changed its approach to SSRIs based on what Australia has done. Now, the point that I want to raise with you is that if you look at how Australia established a research base to justify that, it went back and it looked at pilots who had been flying over a 10-year period whilst medicated, and the evidence, the outcomes, as Mr Navanthe correctly points out, you're looking for, were incident and accident reporting. And so if we've got now 25 years of flying, just like CASA sponsored a study to go back and review the safety outcomes, and the measures were accidents and incidents, and on that basis concluded that Australia should go to ICAO in the world and say this is a valid and safe way forward, then that is where we should be spending the money to go back and revisit the safety case, because if we count up the number of accidents that have been attributed to people with mental health issues, they far outweigh the one accident, and even that is disputed, where colour vision was a factor. And certainly if you look at the record of Australians flying, there is a long history across a broad range of roles where that has been proven. Now, if we've done that with SSRIs, why is CASA not taking that approach of using the data we have, and we're the only nation in the world with that data, just like we were with SSRIs, to prove that the world's thinking, based on theory around CVD, does not reflect the reality?
Well, I think it's a matter of, and I appreciate what you say, Senator. As I said, we can move forward with the science and with what we know. In other words, empirical and the other type of evidence that we can gather. As far as doing that now, why haven't we gone and done it? Because we're looking at a very small number of pilots compared to the population of pilots in Australia. It comes down to resources. I cannot fund a study into colour vision deficiencies and moving forward. As for the age of increasing the age to 65, many countries in the world were involved in that. I was involved in that outside of Australia. And in fact, the interesting thing was, and just as an aside, one of the few countries that opposed it was an African country, where they pointed out that with the age of 60 for a commercial pilot at now, their average life expectancy was 58 anyway, so what was the point in putting it up to 65? So there's been a great deal of discussion around the world about age. I agree when it comes to treating depression, and Professor Navati may wish to add more, and that we have done very well. There certainly are people flying in Australia that I know would not fly in other jurisdictions. And I think it is a worthwhile project. to review colour vision deficiencies and to review the data we have. I just can't fund it, and it's not a high priority to me.
Okay, last question then. Dr. Navathe, given the statement you made in your submission to the latest AET inquiry, that you said CVD pilots pose a significant risk to the safety of air navigation in any role, and that risk can only be mitigated by imposing conditions that limit operations to those environmental conditions that limit the opportunity for errors, and that's a quote from your submission. Were a study to be done, as I've just discussed with the Director of Aviation Safety, that had a similar outcome, that demonstrated on the same basis that we did the SSRI study, that there was no decrease in safety, would you support colour vision deficient pilots being able to exercise the privileges of the licence that they hold?
Before I answer that, Senator, I'd just like to make one point about the quote that you made from the O'Brien matter. I'm unsure as to whether I'm allowed to mention something which is in a tribunal, but what you've quoted is actually with reference to people who have not undergone testing for colour vision deficiency. In Australia, there are a large number of people who have failed the initial test, that's the Ishihara test, and have thereafter continued to fly, and have not undergone any detailed testing which identifies what's the level of colour vision defect. If I can just mention colour vision, there used to be a time when people said people were colour blind. That's no longer the case. We have if I may be allowed, a spectrum of colour vision deficiencies ranging from one cone, abnormalities in two cones, and so on. And so if we know what is the size of the defect, then I have no difficulty about being able to make a specific decision in a specific case. The other point which you raised a little while ago about natural justice and the fairness of doing the CAD test. In Australia, the CAD test is not, in the occasions that it has been used, it has never been used as the endpoint, as it is used in other jurisdictions. In other jurisdictions, you fail the test, that's the end of the story. As you know, Senator, in this matter, this person in point has failed the CAD test and has been given a certificate because we are looking at the extent of failure as one of the many factors which you identified as being useful in making a certification decision. Talking about the depression test, the study which was done for depression, the study which was done for depression was supported by all the other work which had been done on depression. There's a large amount of work which has been done on depression which suggests that, and I don't want to go into detail about it, but the fact that a person who has been provided with treatment for a particular period of time, the risk of remission dropped off. So the main reason for allowing that to happen was that there was empirical independent evidence that it was safe. It was then implemented, and then we did a non-inferiority trial to show that it was no inferior and there were no greater accidents in that case. I'm very happy for us to do that sort of a study if we have the funding for it. But what will be required is that every colour vision defective pilot in Australia will have to be colour vision tested to know what is the actual deficiency. And some of them will then meet particular levels and some of them will not. And so, you know, if we go down that path, depression is a single condition because we talked about, well, you know, unipolar depression. Whereas with colour vision, we are dealing with about 8 or 9 different diagnoses under the umbrella of colour vision deficiency. So that's the difficulty in what you've raised, Senator.
I'll just finish with one last question then, just to repeat. If the study indicated that there, for the range of people who have been tested, that there was no detrimental safety outcome, would you support then people, even those who'd failed the 3 levels testing, including the CAD, if they could demonstrate competence to fly the aircraft under a range of conditions that CASA specified, to exercise the privileges of their licence?
We support that today in individual cases, Senator. We don't need, I mean, the study would be helpful, but today, when a decision is made on the basis of a test which has been done, we look at that test not in isolation, but in the context of all the other things.
I'm meaning to exercise the privileges of their licence. So, for example, the captain, ATPL, if they've demonstrated over thousands of hours an ability to fly single pilot, part of a crew, by night, in cloud, and that study was done, would you support that decision?
If we were able to do a study at that level of granularity, then it would certainly be strong evidence to support that, Senator.
I think the presumption is, Senator, that we would be taking the assumption that the person does meet the requirements. We'd be looking for the negative indicators, not saying to take something away, but as I said the other day as well, if there was such a study done, funded by the government or whoever, with everything else that Professor Navati has added in there, then I can see myself, as following on from what I've just said, that I wouldn't issue it. I would issue it.
Okay, thanks, Chair.